Hi, Stephanie. Can you hear me now?
Now, I,
No? Let me try something. I cannot hear you.
oh, okay.
I can hear you now. Give me one. Hey, Stephanie. Good morning.
Hi, how are you?
I'm doing awesome. How about you?
Great, terrific, actually, terrific.
Good, 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 good. All right. Let's start with any updates since last week, last time we spoke. Any updates on the immigration?
So yeah, here's a kind of a big update that has happened, and that is executives from a staffing company were charged with visa fraud. This happened in early July. So interesting because the charges seem to surround these staffing agencies where the company has petitioned for an H-1B employee to go to like client A when really they're not slated to go to client A. You know, maybe they're really don't have a position for them. So they slated them to go to client A. They filed a petition for client A, and then really client A's contract um, was for other employees or even expired. So interesting that the federal courts have now indicted the principals in that company for this conspiracy to commit visa fraud. So it's huge because there are a lot of challenges in filing H-1Bs for employers.
Right.
One is um, a statement of work. Like if I'm filing an H-1B on April 1st for a CAP case, I may only have a very limited statement of work. I may not have one, for instance, that goes to October 1st, which is the start of the fiscal year. So your H-1B is going to start on October 1st, although under the CAP we have to apply April 1st. So, so companies, I think, have tried to get creative in applying for an existing open SOW, for instance, statement of work or master services agreement. And it seems like this might be, I haven't read the entire case, but it seems very similar to what this case involves, is where the company said, well, we know that client B is going to provide a contract for another case, so we'll bring our staff onshore on client A's open statement of work, an open work master services agreement, and then we'll amend the case afterwards so that then they'll have a legitimate project because we're confident by then that we will. Now, the fact that the federal court is now indicting these executives for visa fraud over this means that you can't run a scheme like this. You really have to pay attention and petition not for prospective employment and not for questionable employment, but for real, consistent, and true employment. And I think, for me, this emphasizes the fact that an employee obviously would not know about this scheme, but this really puts the employee's status at risk. Can you imagine that you have an H-1B pending or even approved with an existing an employer, and because of the documentation even in this case, this was a scheme, but because of the documentation, even if it's not visa fraud indictable, for instance, there are issues where, for instance, the employer will petition for an in-house project. And there's an in-house project going on, and there is a legitimate product that they can work on, but really the true intent is to get them on a third-party contract once they arrive in the United States or once the H-1B is approved, so they'll file an amendment. Now, I've had at least one inquiry where notices of intent to revoke were issued where an in-house project was used as the basis for an H-1B, but when a site visit was conducted, the employer came in and looked at the product. I'm sorry, the USCIS fraud investigator, which
Hmm.
we call FDNS investigators, fraud detection unit. They came in and they looked, and the software didn't even work. Were they working on it? Maybe legitimately they were working on a product, but it just wasn't operating at the time. But when they looked at that product, it wasn't working at all. So they started to revoke the visas for the beneficiaries in that company.
Hmm.
Now that's a huge problem because as a beneficiary, you may not know, for instance, that that project's not legitimate. You may not know that the company is trying to do this where they're just trying to get a higher approval rate or kind of game the system, right? In order to be able to petition for you. Because realistically, USCIS doesn't understand, for instance, the IT industry or the engineering community, where an engineering client is not going to issue a 3-year statement of work. They're going to issue it in increments, right? 3-month, 4-month, 6-month increments for a statement of work. And they're certainly not going to give you a statement of work in March of 2019 for a project starting October 1st, 2019. Most end clients wouldn't even have procured the funding for that project. So, for instance, right? So some of those statements of work are generated based on quarterly budgets. That's why they're issued on short terms. So they're not going to look ahead 6 months and say, okay, yeah, we'll give you a 3-year statement of work for this future project, because they haven't yet secured the funding, even though they're trying to get, the personnel in line, because it's just how the industry works. So you got to be really careful. And I said, for me, what I would emphasize is that it's really important to understand your rights as an employee, one. Number two, to really understand your petition. I would encourage employers to give a copy of what we call the stamping packet, which is the I-129, the LCA, and the cover letter and the employer support letter. Make sure that at a minimum, the employee gets that. By the way, the employer is required to give the employee a copy of the LCA and have you sign for it. So especially if they're H-1B dependent employers, if you haven't gotten that, or if the details on that are incorrect, that's a problem. And actually, in that fraud case, they did build a bench of job candidates. That's what they were trying to do, right? Build a bench of job candidates so that when they got legitimate projects, they could file an amendment and move them. That's just not the way the system is designed. And what the federal government's doing here is really setting up, giving us a line in the sand and saying, you cannot do this because this is visa fraud, right? You're lying. So whereas, I have to say it's probably a pattern in practice that's fairly widely used. And I think that federal prosecutors are going to really start looking at this now. So where it leaves employers is don't do this, right? Legitimate projects only, and make sure that you have them in place. And that's going to require the industry to, and industry leaders to really talk to end clients. From the employee's perspective, this leaves, these employees with notices of intent to revoke. This leaves them, out cold. Some of them probably have been here on H-1B for a long period of time. They've changed employers, right? And they think that they have a legitimate and good employer. And I would just say to H-1B workers, be careful. I mean, it's your future. You could have a revocation and you could be sent outside the U.S., even though you haven't done anything wrong in accepting employment. The other thing is, if you're brought on to an employer and they say, we're going to put you on this in-house project, then we'll move you to a third-party client when we get a contract with a third-party client. Get the documentation. Say, okay, I'll sign a non-disclosure agreement, but I want to know that you have a solid in-house project before I'll agree to this, because if it's not a legitimate in-house project, then obviously your H-1B could be revoked later. And also, if you're working on an in-house project, at least if you can, I know there's a lot of evidence that you won't be able to snapshot because it belongs to the employer, like anything that relates to the product, for instance. But what you can track is your own timesheets showing the work that you've done on various projects. So if you're working in-house and you're sitting in the employer's work site on legitimately on your H-1B, and you're physically working, keep records of those timesheets if you're doing it. Keep your own record of what you did. That way you show that you didn't violate the terms of your H-1B. Also, if the employer gets a request for evidence later, because some employers legitimately have an in-house project They're just willing to put their H-1B workers on it temporarily until they move them to a third-party work site. So if that's the case, then you may actually be helping the employer with a future request for evidence by keeping track yourself. So what I'm encouraging employees to do, I guess, H-1B employees, is really to take an active role in your immigration status.
Definitely.
Don't just sit back and expect the employer to do things for you and answer the request for evidence. Take an active role in it. Understand what the issues are in a request for evidence. Get a copy if you can and look at it. If you think that employer is doing something wrong, do not take that job. Do not find another employer and get out of it, because the way the fraud detection is going, and these indictments show that it's even gone beyond fraud detection, but the way these fraud detection units are issuing notices of intent to revoke and revoking H-1Bs, I mean, I've never seen this level before.
Gotcha.
Revocations. So I just wanted to encourage employees to really take an active role.
Yeah, definitely. Thank you so much for that input, because one of our family friends have actually faced this situation recently. And having said that, it's more about questioning the intent of the employer by FD&S about, okay, you might have a future client, but again, is your in-house project that you're claiming for initially, is that legit? That's what they're questioning, right? The intent of the employer.
And do you have the funds? Like if you're getting a job with an employer that has 3 employees and they're a product-based company, but they're a startup, probably not the strongest H-1B, unless you can show that they have to show USCIS, for instance, that they have strong financials and have backing financially to be able to put H-1B workers on an in-house project.
Gotcha.
Because if it's a startup that doesn't have financing and they're just shoestringing, they're going to put you inevitably on a third-party client site. And what you have to think about is, okay, I'm doing this in-house project, but you also have to think, I need to legitimately be working actively on a project.
Right.
If you're not working on an in-house project legitimately and there's not extensive documentation, it's not worth transferring to that employee and the employer. And I know what happens, right? Employees, there's almost like a desperation, like one employer is not working out, and you think your friend or somebody knows this other company and you want to join them, but really we have to be very careful about the choices we make now and make sure that you're joining the strongest employers.
Gotcha. And then always make sure LCA is properly filed whenever there is any change of employment.
And demand a copy. Yeah, if you change employment from like an in-house project to a third-party work site, or if you're changing a third-party work site, that employer is required to file an LCA before the change is made. And they're required to provide you a copy of that LCA, and they're required to file an amendment before you move. Make sure before you make a move that amendment has been filed. In fact, you may want to ask for a receipt notice for that amendment to be filed before you pick up your family and move 2,000 miles to a new work site.
Yep.
Because we see it where companies forget, fail to file because maybe they're a large company and they're moving a lot of resources. Workforce management isn't clear on the changes, and the person will be moved and never see the amendment filed.
Right.
And most companies are pretty good right now, but again, this is about taking that active role. The other thing is check your LCA, because if you move to a new work site, the wage level may go up, may change. Make sure that your employer changes your wage based on the new work site. Like if you're moving from Ohio, or let's say you're moving from like even New York City to Southern California, your wage level is going to increase. There's just no doubt about it. Or Washington State, for instance, Seattle area, or Bentonville, Arkansas to Seattle, you're going to get a huge wage bump.
Sure.
That LCA is going to have the new prevailing wage on it. That LCA is going to have your new offered wage. That's the wage that you should be paid. Very common for us to see employers who don't bump that wage up when somebody moves, not because they're trying to save money, but because it's just an oversight, like communication between workforce management and payroll. And the person, gets a request for evidence on an extension 2 years later, and the company owes them $25,000, $35,000 in back pay. And, in the past, we've been able to make that payment and say it was an oversight when they moved. but technically, that company wasn't in compliance because they were not paying the prevailing wage in that area. So, look at your LCA and make sure that if the LCA shows a different wage than you're earning, make sure you actually earn that wage on an annual basis. And really, this is about, again, taking that active role. It's really essential today.
Definitely appreciate that insight. One more question. Any new update on H4EAD and GC processings?
H4EAD, it's just a matter of time. We haven't seen the official update on eliminating the program because they're going through the Office of Management and Budget to get it approved right now. But we should see that probably by the end of the US summer. So by the end of August, we should see something come out about H4EAD. It's going away. We just absolutely know that H4EAD is going away. And it's just about the government getting through this processing time. And issuing the rule, so to speak, the promulgated rule. So enjoy H4EAD while you can. Keep applying until you hear an official notice that it's been revoked, because I suspect that the system, the way it's going to work is they're going to stop all processing at a certain point. And then if you already have an existing case in process, you'll get a shorter validity, but you'll still get some valid EAD time.
Gotcha.
And if you have a case that's already approved and you have validity through 2023, for instance, then you'll likely keep that because they can't really take back the EAD. It's very difficult to render an EAD invalid because you already have it. You already have the social, right? So I would say that's probably going to see a phase out of the program with new petitions ending, maybe even with the new fiscal year if they can get it done quick enough. But they're moving very, very slow right now. Even the management budget just hasn't moved this forward. It's been sitting there, I think, since April. So, it could be several more months, but I would say as soon as you're eligible to apply for an extension, if you're waiting for an extension or an H4EAD, do it, get it in the system, and until you hear something about a cutoff. So
Gotcha.
get that done. And in terms of updates on the green card front, unfortunately, we're going to stay retrogressed. EB1 is going to continue to be retrogressed at least through the end of the fiscal year. We're back to 2015 right now, retrogression. Now, the State Department is reporting that they hope in October 2019 to bring that back up, EB1 back up to 2017, say in the EB1 India, for instance. It was 2017 until I think May. The June bulletin retrogressed it to 2015. They are hoping by October 2019 to be back up to 2017 numbers. That means if you have let's say at least by October of 2019, after the new fiscal year starts October 1st, you'll likely see if you have a priority date before November 1st, 2017, then you'll be eligible to file your adjustment of status or to get your green card. Right now it's back to 2015. So it's really stopped, in essence, stopped the EB1 processing for a great number of people who applied between 2015 and 2017.
Right.
Nevertheless, we should see that uptick in October, certainly by the end of the year. Just one word of caution there. USCIS processing times are quite slow. So if you haven't had your interview, if you're in the US for an adjustment of status, just expect those adjustment of status interviews to take time. We're still looking at numbers in most jurisdictions around 18 to 29 months wait time for an interview for EB1 or employment-based petitions all around.
Wow.
Expect there to still be some delay. This has given the field offices time to catch up. I mean, I just had an adjustment of status interview for a marriage-based case. They're in Atlanta, they're reporting that they're taking about 18 to 32 months, but this was 6 months we had the interview. So, I'm hoping that things are improving. The retrogression obviously gives us time for things to improve. But if you're certainly sitting in that kind of sweet spot between 2015 and 2017, November, expect some movement before the end of the year, at least with the priority dates.
Okay, cool. And is this just for EB1 or the overall program?
That's just EB1. EB2, I don't think it's going to move. Yeah, I don't think we're going to see movement in that this year. EB2 is going to stay kind of behind EB3. We might see some movement in EB3 by the end of the year.
Okay.
End of the calendar year.
Okay. So we don't have any updates on the bill, right? The processing of the bill or?
No updates on the processing of the bill. It's going to move slowly through Congress.
Okay. Slowly. Question is how slowly? Okay.
Well, and keep in mind that the session goes till January and January only. So whatever bills are presented now, if Congress doesn't move fast enough and get those bills through Congress, that means through the House. Well, right now it's in committee. If it has to get through committee, get to the House floor or get to the Senate floor, and get through both chambers and approve before January. And between that, you have Thanksgiving holiday in the U.S. You have a long Christmas holiday and right now Congress is not in session.
Okay.
So you really only have maybe 100 more days in which that bill could move. And I just frankly don't see it moving this year. So when the congressional session ends, that bill goes dead. They'd have to re-offer that bill or relaunch it basically with the new session.
So basically it starts all over again if it doesn't go through.
All over again.
Gotcha.
Yeah.
We have seen this.
Except for the negotiations that have already taken place, obviously, individual negotiations between House members or between Senate members have already taken place. So maybe it'll go through more quickly the second time. But this is how the Gang of Eight bill died, right? It just at the end of the year and it went away and then sentiments change.
Right.
Especially when 2020 is an election year. So don't expect anyone to stick their neck out or do anything.
Gotcha.
Because if it doesn't happen this year, I don't see a lot happening next year.
Definitely.
With the election, unless somebody wants to be magnanimous and say, look what we did for, high-tech workers, right? But no one's going to take a chance on an election year.
Wow. That's okay. Definitely. No one should raise their hopes on that yet.
Right, exactly.
Okay, one more question if I can go back to the H4 EAD part, right? Sure. So what we are necessarily saying is don't plan for your extension for certainty, but again, the original intent of this program, I believe, is to help any of the educated or professionals who are looking to get a job instead of falling in that H1 queue. That was the original intent, right? So what is the challenge against revoking? I mean, why is it even being challenged, H4 EAD program?
It's not being challenged. It's literally right now, the administration is putting it through the process. Office of Management and Budget, after the Office of Management and Budget approves the rule the way it's written, based on how much it'll cost to eliminate the program, then they will send it over to the Federal Register. The Federal Register will be announced, and you'll have a 30-day comment period on the H4 EAD. And then after the comment period, it takes them a while to promulgate. So that what they're doing is they're trying to properly promulgate the rule. Sometimes they just do things by executive order, and that's not happening here, which is good because it gives us more time. But it's not being challenged at all, to be honest with you. Even when it's published in the Federal Register, that opportunity, by the way, I'll post whenever it's available for public comment. When it's published in the Federal Register, there'll be comment period. Do take advantage of that. It's a public comment available free for everyone. That's one thing. But that takes time. Then once the comment period ends, they have to basically answer all the comments, and then they promulgate or issue the final rule through the Federal Register. So I wouldn't call it like a challenge at all. I would say it's bureaucracy, honestly. And they have to kind of work out, how do you end this program? So I have to say, this administration so far has pretty much just done things kind of halfway, to where we want to eliminate this, we'll do an executive order and it'll be gone. And then there's all kinds of questions or challenges in court. They're trying to avoid that here. That tells me they're really intent on ending this program. And it's unfortunate, right? I mean, we know the impact of it, that it's going to impact spouses.
Yeah.
Every family in America has almost a two income house. If you don't have a 2-income house, then you're making sacrifices, right?
Yeah.
So, and the same thing goes for H-1Bs and H-4 EADs. And it seems to be the administration ignoring the beneficial economic impact of having H-4 spouses in the workplace, because it's more money, more taxes, more activity. They're certainly not taking anybody's jobs by being on an H-4 EAD. It's just supplementing the workforce, and unemployment is at an all-time low. So there are a lot of benefits to the H-4 EAD program. This is all political. Honestly, it's all political.
Okay, very true. So yeah, when I say challenged, I mean to ask, why is it even being, considered to, the extension being stopped or anything? Is it based on the budget, or what exactly inspired?
Politics. It's just politics. It- there with the rhetoric that you hear in American politics right now, especially with the Trump administration, is that they want to support investors and they want to support high tech workers and they want to get rid of the low level workers, right? That's just not true because we see it in the H-1B program that they're actually putting up barriers to legal immigration across the board, and especially with high tech workers. Even when all of the paperwork is legitimate, we're seeing a really excessive amount of requests for evidence, notices of intent to revoke, yeah, site visits for companies that have a very, very good track record of, consistent and beneficial service and, and employment to high tech workers. They're really highly compliant. They're engaging with the government agencies.
Mhm.
And we're seeing that engagement pull back. And the government agencies now are just issuing high level RFEs. So I think in the news, you probably hear, certainly the administration saying they want to support high tech workers. But in reality, we see the reality as H-1B, as attorneys who work on the H-1B program and the L-1 program, and it's just a wholesale attack on limiting even legal immigration in the United States.
Right.
So it's an unfortunate kind of time period for the H-1B program, but I guess these indictments show that they're really serious about how they attack the program. So they're going to do it on all levels. So requests for evidence, indictments, you name it.
Gotcha. There is no guarantee at all.
No, and if you're in, it used to be, again, I've been working with H-1B since the year 2000, so 19 years, and it used to be you could kind of plan on 6 years, and then, if you're on H-1B and you're from India or China or a backlog country, for instance, then you could, beyond 6 years, you're waiting for your green card and you're continuing to extend your H-1B. And, I've had clients who've been on H-1B 12 and 15 or 18 years and then finally got their green card. You just can't guarantee that anymore. So I guess one of the things I would encourage H-1B workers to do, I used to say, when you reach the first extension, year 3, start talking to your employer about filing your green card, your perm.
Mm-hmm.
And, that gives you some time so that by the end of year 4, hopefully your perm is filed or at least initiated.
Mm-hmm.
And I would say now the H-1B worker should start talking to their employer at the beginning. Obviously, the first year it's difficult to do that, but start getting that perm application in as early as you can.
Mm-hmm.
And look at alternatives. I mean, there are alternatives out there to the H-1B. Some of them are kind of, tricky, right? Some of them involve, like, if you want to if you're from India or a non-e-visa country, for instance, where you want to qualify for an e-visa,
Mm-hmm.
which is an investor visa. I mean, obtaining citizenship in a third country that has that is e-visa eligible is an opportunity. Usually it requires an extensive amount of money that most H-1B workers wouldn't have, but that's one way to get onto the e-visa. There is one other topic I did want to just mention.
Okay.
Because it's come up several times in my practice in the past couple of weeks, and that is, with the uncertainty surrounding the H-1B program, I see a lot of H-1B workers forming their own companies or wanting to form their own companies.
Uh-huh.
And I just want to emphasize that an H-1B worker can own a passive investment in the United States, but you can't actively be working for your own company.
Sure.
If you don't have an H-1B for that company. So if you're working for company A and your H-1B is with company A, you can't, with a few friends, establish a company B, and work actively in company B, because now you're violating the terms of your H-1B because you don't have an H-1B to work for company B.
Gotcha.
Only work for company A. So I just want to caution H-1B workers that if any investment that you make in the United States, you should look at the tax consequences and talk to a tax advisor, 1. And 2, you should really make sure that that investment is completely passive for you.
Gotcha.
If you're working actively and trying to start another company, then you are violating the terms of your H-1B. So be very careful there.
Okay, definitely. We can talk more about the ideas, if it's okay with you, later in our next week or a couple of weeks from now, where specific investment ideas like real estate, Airbnb, something like that, where they can invest, and then basically it's more running in the background, right? They're not actively part of it.
Exactly. They're not taking an active role in property management, for instance, but they have a company formed and they have somebody else running it, basically.
Right.
Something.
That's definitely an option. That will be a good topic for us to discuss, because that also opens up some of the, as you mentioned earlier, it's the life standards, no sacrifices, right? So when these programs are being, revoked or anything like that, they'll have another option. So that's definitely one thing. And Stephanie, if you don't mind giving your input on basically what is the current status on how much investment for the e-visa that you talked about?
Oh, so for the e-visa, so for instance, one thing that we do with clients is if they're coming from a backlog country like India or somewhere, that they're going to face a long backlog and they want to just get in, get some more security, or they're entrepreneurial and want to run their own program. What we do with some of those clients is we have them, they're able to secure citizenship, say in Grenada, with an investment in Grenada, and there's citizenship programs, say, for that country, and there are other countries. And then they invest in the United States in a myriad of companies. The baseline investment really for an e-visa really depends on the market that you're investing in. So if you're investing in a Subway restaurant or something of that nature, the investment's going to be under $100,000 because that's what it takes to start a franchise for Subway. If you're investing in a landscaping company as an e-visa holder, you may be able to do that for $25,000. I personally like to see $100,000 plus. Most of my colleagues do, but there are small dollar e-visas where it's under $100,000. But it just depends on that market. How much does it legitimately take to set up an e-visa, to set up a business in that market?
Okay.
And that takes a little bit of a market study, right? So I can set up a landscaping business certainly for under $50,000. I just need a truck, a couple of guys, and the equipment, right? And I might be able to buy that, for under $50,000 for somebody who wants to get out of the game, right? But like if you're starting an IT company, it's going to take a lot more investment. You can do it on a shoestring, but on the e-visa doesn't allow you to do it on a shoestring because they want to see how you're going to grow that company and how you're going to invest in that company such that it benefits the U.S. economy. So it really does take a market by market study and how much is it going to cost to start that business in that company, in that area. I wouldn't say, hey, I only have $40,000 that I can track, so I'm going to start an IT business and just try to keep it going with $40,000, because that's probably going to be considered marginal for that type of business. But it's not going to be considered marginal, for instance, on a landscaping company that you're going to employ seasonal workers, or even on an ongoing basis, or a construction company, even something of that nature where you're doing subcontractors.
Gotcha.
So it really depends on the market. If you're interested in e-visas, I would say really do your homework as far as the type of investment. I like e-visas where you're buying an existing company. The e-visa applicant only needs to own the majority of that company, right, or half of that company, so you could own it with a U.S. citizen, and that's fine. You could have two people, and that helps with marginality. So if you have $75,000 to invest, but it takes $150,000 to start that business, maybe you start that business with a partner. That's one opportunity. So there are a lot of opportunities out there, but again, just to mention, the e-visa also does not lead to a green card. So it's a temporary visa. So it's not something where
very true.
It's not something where the e-visa, you're going to take the e-visa and run a company for so many years and then get a green card. There are some instances where you already have a green card pending, or you have a family member who may apply for you later where you might be able to do it. But that's something where you have to really consult your attorney on the specifics.
More about the supplemental income, though.
The supplemental income will come from the e-visa company,
Right. So can you give us an update on the EB-5, so the investment limit? the 500K and the $1 million, we have been hearing news about that being changed to 1 million and 1.4. Is that right?
It's coming. Yeah, that's another thing that's kind of kicking around in Congress. They're talking about 1 million. They're also talking about 925,000 as the baseline, and 1.4 or 1,025,000.
Okay.
Those are the numbers that I've heard. Again, nothing concrete in Congress. You won't see it this year, I don't think.
This year, as in until next year, May, right?
Until, yeah, and maybe next year, because even though we've been talking about this and we've heard this for like probably the past year and a half, there's nothing concrete in committee that has changed the rule. So I think for right now we're safe with the current $500,000 investment. I should say under the new system, you're really talking about that 1.4. You're really talking about the higher threshold, because all of the conversations that I've heard surrounding that lower investment, which usually requires a targeted employment area like 500,000, is in place because that 500,000 investment is being made in a targeted employment area. Really what we'll probably see is that either that being eliminated, the targeted employment area, or greatly reduced.
Gotcha.
So you're really talking to get into an EB-5 in the future, you're probably talking about over $1 million. So, just to keep that in mind. Traceable funds, by the way, you have to have that source of funds and show exactly where the money came from. So if you're selling, if you buy a bunch of properties in your home country, sell them all off, and you can show that you made $1 million from that sale, that's perfect, because you have the bill of sale, you have the money going into your account, and you wire it here for the EB-5. But you also need to worry about backlog with EB-5. So EB-5 India will probably be backlogged in the future. EB-5 China is backlogged. Vietnam will be backlogged. And India will probably be backlogged. I have to check the update, but it should be backlogged probably this year.
Wow.
Maybe next year. So.
Yeah. Stephanie, thanks for bringing the traceability aspect. I have a question on that, if you don't mind. So the traceability, right? Should the investment always come from your home country, or let's say one of our friends I know has saved about 500K, I believe. Is he eligible?
Yeah, he's eligible. It doesn't have to come from your home country. In fact, like in India, for instance, you can really only get 250,000 out at a time, right? But it doesn't have to, as long as it's traceable to you. The source of funds comes right back to you. So if you own properties in Singapore, for instance, or a business in Singapore, and you sell it, but you're an Indian citizen, that money can be wired as part of your EB-5. Just remember that I think some of the challenges with India and the EB-5 have been is that source of funds, because business owners say, oh yeah, of course I have the money. It's like, yeah, you have the money, but can you prove where the money came from? Because it can't be black money, right? It has to be really traceable money. Somebody paid you for something and it's in your account, and I can see that money going into your account, and I can see that money coming out. So that's the source of funds becomes a very important issue.
Definitely.
But it doesn't matter where you get it from. You can have investments in Europe and Asia and all over, and just combine those investments as long as you can prove where that source was.
Gotcha. Even your hard-earned money in US, right? I mean, once you work for a certain period of time, you should be able to save that much if that's your goal from the very first day.
Yeah, exactly. You should be able to save that much. Exactly.
Good. Stephanie, so one more question. So e-visas and H-1Bs, right? Let's say we definitely give out suggestions in near future where these are the type of businesses where you can invest and then be very passive. Let's just say that business investment, for example, Airbnb, right? So I start building a portfolio. I don't have to have investment of hundreds of thousands of dollars right away, but again, maybe a couple of thousand will get me a property up and running. But having said that, over a period of time, if you can grow this business really passively, being in the guidelines, following all the guidelines, right? And never be active in the business. But again, this business has grown in such a way that it's worth that much, the 500K or something. Now will it qualify? Meaning it's not a straight up 500,000 investment, but it has been a 500,000 investment over a period of time. Will that qualify?
Well, I should say, talking about Airbnb specifically, residential real estate is not the best e-visa. Not the best e-visa because it's hard to to get USCIS to understand the e-visa, right? I mean, to understand that investment in residential real estate and how it grows.
Mm-hmm.
If you, for instance, again, keep in mind the purpose of the e-visa is to employ U.S. workers. So they're giving you an e-visa because you're investing in the United States, and that's going to help the U.S. economy and potentially hire U.S. workers. So if you had an e-visa company that had 15 residential properties, let's say in the mountains of Georgia, and you were renting those out on a weekly basis, and you hired a property manager, a leasing agent, and cleaning staff and maintenance staff, you might have 4 to 5 people on staff. That might be a legitimate residential real estate business, but then we're really talking about property management, aren't we?
Right.
So just buying 5 properties and saying I've made an investment in the United States, give me an e-visa is not going to do it.
Mm-hmm.
So I would be cautious there. Potentially, I like, if you're thinking about real estate, I like commercial investments.
Mm-hmm.
I like buy a strip mall, and then you have the rent from those, and then you have the indirect employment of U.S. workers through the strip mall, for instance, right? I like that more than residential real estate. I like, and that could be very passive. You could have just one property manager running that for you, and a maintenance worker. I like those types of investments if you're thinking about real estate, not the kind of investment where, it can't be too I understand what you're saying. For the H-1B, it has to be passive, but for the e-visa, it has to be something that is going to probably employ U.S. workers. So I would look toward commercial real estate for that if you're thinking real estate. But there's so many other businesses that you can get into on the e-visa side. Mm-hmm.
Yes. So I'll set up something for future where we'll only talk about the business ideas.
Yeah,
that will give our subscribers some idea about what they are interested in, and then do what with their savings. Or
that's a good idea. And we should also get an accountant on the call that we can talk to that accountant about the exit tax. There's a 23.8% exit tax if you're a long-term resident of the United States and you leave and you divest yourself of all your U.S. assets, you may be subject to that exit tax. We need to talk about under what circumstances with an accountant that you might face, that exit tax when you leave the United States. So definitely, if you're a permanent resident, you're giving up your citizenship, or if you're a U.S. citizen going back to your home country, for instance, after living in the United States for a long time, definitely would apply to those people. But we can talk to an accountant about some of those tax strategies.
Definitely. Mm-hmm. Absolutely. I can appreciate that. I have set up something with Umang Thakur this weekend. I'll also appreciate if you can share one of your CPA contacts. We can ask more questions around the subject.
Sure. I usually go to Umang, so just so you know. But that's great because I'll be there in Atlanta, so we can. I think he's coming back from India this week. So.
I think so. Yes. Definitely. Really, thank you so much, Stephanie. I'll send you more questions your way, and then I'll collect them from the subscribers that we have so far, and then this will grow definitely because we are addressing the current issues, and then our main theme is, as you know, how can this add income to our H-1B holders, right? How can they invest by following all the guidelines, but again, getting that supplemental income?
Yeah, exactly. And then, my bigger concern then would be what happens if you get the supplemental income and you have a company running here, even passively, and then you lose your H-1B and have to leave the United States.
Definitely.
That's a big impact on employees.
Yeah. The reason I'm very, very much interested in this subject is because every business, every situation is different. It's not that for one situation, Airbnb is good, but again, for others, it might not be, just based on the location or the type of activity that they are involved with. So I'm really interested in addressing the subject.
Yeah, absolutely. I agree.
Definitely. Thank you so much, Stephanie.
Thanks.
Catch you later. Thanks.
I'll talk to you soon. Thanks, Bobby.